Now we consider concurrent ownership and future interests. Concurrent ownership is commonly tested both on the multi-state and on the essays. This material is quite straightforward, and it's also tested ritualistically. The same issues come up, and they're tested in the same way over and over again. We know, broadly speaking, there are three types of concurrent ownership: a tenancy in common, a joint tenancy, and a tenancy by the entirety. Of these, the tenancy in common and joint tenancy are the more commonly tested. And of these, a tenancy in common is the simplest and the easiest to understand. A tenancy in common is where we've got two or more tenants. Each of them may convey or devise their interest in the property, and there's no right to survivorship. So a tenancy in common, to some extent, is the most flexible form of concurrent ownership. Both parties have got a right to either convey by contract or devise by will their interest in the property. That's a tenancy in common. Now compare that to a joint tenancy. The biggest difference between a joint tenancy and a tenancy in common is that a joint tenant cannot convey his or her interest by will. However, a joint tenant can and frequently does convey their present interest by contract. That's the biggest difference between a joint tenancy and a tenancy in common. But as we consider a joint tenancy, we see that this form of land ownership is a little bit more complicated. In order for a joint tenancy to be created at common law, there had to be a unity of time, a unity of title, and a unity of interest. Modernly, all we need is the intent to create a joint tenancy and a unity of interest. So modernly, a joint tenancy is a little bit more easy to create than it was at common law. And undoubtedly the most commonly tested issue with regard to a joint tenancy is the issue of severance. And there are a few ways in which this issue can come up. For example, the concurrent and simultaneous death of both joint tenants does not constitute a severance. Under those circumstances, the estate of each joint tenant will take their proportionate share of the property. But consider the effect of a mortgage on a joint tenancy. A mortgage by one joint tenant severs the joint tenancy and creates a tenancy in common only in a title theory state. In a lien theory state, the mortgage of a parcel of property by one joint tenant does not constitute a severance. Now, this is a fairly annoying little issue, but it is tested routinely, and it is not difficult. It's one more of those little details you've got to figure out a way to get into the back of your mind. I counsel you, practice, and perhaps make a short flashcard on the topic. Where we've got an issue where we've got various joint tenants, two or more joint tenants, all of them convey their interest to one other party. So two or more joint tenants all conveying their interest in Blackacre to party X. There's no severance, and party X will end up with a fee simple absolute. Probably. Again, it depends on the factual situation, and you've got to look carefully at the relationship between the parties and then dissect it accordingly. This is a subject that requires careful organization, and as we get into it, we see the actual law isn't nearly as difficult as it might be. Finally, the last type of concurrent ownership is a tenancy by the entirety. This is not that common a form of title, and it is only held by married couples. So a married couple can be tenants by the entirety, and the interesting aspect of this is it's almost as if husband and wife are incorporated for the purposes of holding this property, because the entity of husband and wife holds title to the property. And what that means is a creditor who is a creditor of either the husband or the wife has no way to attach an interest in property that is held by a tenancy of the entirety. The only creditors that have access to property that is held in this form would be a creditor to both of the couple. So if you're a creditor of the married couple, you can go after a tenancy by the entirety. But if you are merely the creditor of one or the other, you cannot. And that's really all we need to know for a micro review about concurrent ownership. Again, I counsel you, I evangelize to you. Go out and practice. You'll see that there's plenty of little details that you need to know. But don't get lost in the maze of tiny details. You've got what you need to know. Go practice and then master those details. So for the remainder of this short video, let's return to future interests. I touched on future interests with regard to their connection to present possessory estates. That's the best way to become oriented, to get a clear idea of what the future interests are and how they arise. Still, these future interests are subject to a reasonable amount of testing. I say a lot more on the essays than on the multi-state, but it's worth studying and worth knowing. So, as we consider the various future interests, let's touch on them. First, a reversion. There's not really very much to it. Here, a grantor gets the property back after a life estate. Fair enough. That's a reversion. But a remainder is a lot more interesting and more complicated. A remainder is held not by the grantor, but by some third party. And the third party achieves its remainderman status. It takes possession of the property after a life estate or after a specific lease term or some other quantifiable amount of time. Third party is a remainderman. We should call them a remainder person, I guess, modernly, but I guess it's one more example of sexist language that's still a part of the law. With regard to remainders, it's worth being aware that there are two different broad types of remainders: a vested remainder and a remainder that is contingent on the happening of some future event that may never happen. With regard to these remainders, the vested remainder is to some extent the more complicated and the more commonly tested. It is possible to have a vested remainder that is indefeasibly vested, which means that the holder of that remainder will not be subject to having that interest reduced or compromised in any way. A person who holds a vested remainder that is indefeasibly vested is about as secure a remainderman as possible. But there are two other types of remainders that are not as strongly vested. First, a vested remainder subject to open. This is where a class gift has been made, so grantor grants to me and all of my siblings a vested remainder, but I may get more siblings, and therefore my interest could be diluted because the future interest that I have is vested subject to open. Somebody else may join the class gift, in which case my remainder, although vested, will shrink to some extent. Also, we'll see in a limited number of cases, one can have a vested remainder that is subject to total divestment, not as commonly tested. We see contingent remainders all the time. These are a remainder where the future interest holder does not necessarily ever achieve a possessory interest because that remainder is contingent on some future event that may not happen. We also see, both in the rule in Shelley's case and the doctrine of worthier title, both of these ideas basically say that the grantee's heirs can't be allowed to be remaindermen. Grantees' heirs are not specifically defined enough to allow them to be a remainder. Now, suppose we've got a situation where the third-party interest is created in exactly the same instrument as the prior possessory estate. And let's suppose further that this third-party interest can mature and the third party can take when the interest terminates. That's a classic definition of a remainder. A remainder is a future interest created in the same instrument as the prior possessory estate, and the third party gets to take when that interest terminates. That's a remainder. A remainder is contingent if there's a condition precedent to the third party taking. And, by contrast, a remainder is vested if there is no condition precedent. Also, keep in mind that a remainder interest is something that can be part of the remainderman's estate. A remainderman can convey his or her future interest by will. And also realize and keep in mind that remainders and other future interests can be alienated before that third party takes. So the third party with a future interest can sell or otherwise alienate that interest. Now, look at executory interests next. An executory interest intrinsically is held by a third party, not by the grantor. And we've seen that there are shifting and springing executory interests. This is almost a point that you don't need to consider at all. And I seriously considered leaving it out as I constructed and designed this program. But the distinction between a shifting and a springing executory interest does come up frequently enough that it's worth my making mention of it. A shifting executory interest shifts between grantees. A springing executory interest technically goes back to the grantor and then springs to the third party. But the function of these two is ultimately the same because the third party gets the future interest, the grantor does not. Next, a possibility of reverter is where we've got a fee simple determinable, the grantor automatically gets the property back. That's different than a fee simple subject to a condition subsequent, because under that situation, the grantor has the power to terminate and a right to re-entry. But the interest of the holder does not automatically terminate the way it does with a fee simple determinable. And that's all we're going to talk about for now, about concurrent ownership and about future interests. Next, we'll consider the remaining issues from land ownership.